What if I told you that your HOA just claimed it could take away your right to carry a firearm the moment you stepped outside your own front door? That's exactly what's happening in South Carolina right now, and residents are furious. An HOA has announced that firearms are banned throughout large portions of the neighborhood, even though South Carolina is now a constitutional carry state. The big question is, can they actually do that? Well, let's break it down. A homeowners association in Myrtle Beach, South Carolina has ignited a firestorm after announcing that firearms would no longer be allowed in what is called shared property areas. According to the report, Forest Pines condominiums informed residents that guns would be prohibited at the pool, clubhouse, sidewalks, parking lots, and other common areas throughout the property. And as you can imagine, residents did not take that news very well. One resident raised a question that many gun owners and homeowners are asking right now. If I'm walking at night and get mugged because I wasn't allowed to carry a firearm, are they now financially responsible because they prevented me from protecting myself? Another resident pointed out that this isn't an apartment complex where tenants are simply renting a unit. She said, "I own my home. I don't rent, it's my property." And that distinction matters because many residents feel the HOA is attempting to regulate something far beyond maintaining the neighborhood. Now here's where things get interesting. South Carolina became a constitutional carry state in 2024 after Governor Henry McMaster signed the legislation into law. That means law-abiding adults generally no longer need a permit to carry a handgun, either openly or concealed. But South Carolina law also contains specific requirements for locations that want to prohibit concealed carry. Generally speaking, signage requirements must be met in order for concealed weapons ban to be legally enforceable. And according to residents, no such signs have been posted at the pool, the clubhouse, or anywhere else within the community. One resident told reporters this: "South Carolina is a constitutional carry state. You can't just do that. There's no signage anywhere." The statement highlights the legal issue at the center of this controversy. Can an HOA create a rule that effectively disarms residents in common areas? Or does the state law override the HOA's policy? And at this point, those questions remain unsolved. But what's also interesting is that this isn't an isolated incident. A similar HOA firearm ban in Florida recently sparked backlash and even drew criticism from Florida Attorney General James Uthmeyer. Now, South Carolina may be heading towards a similar legal battle. As of the latest report, the management company overseeing the community has not publicly responded to requests for comment. Meanwhile, many residents are demanding answers and questioning whether the policy is enforceable at all. And this could have implications far beyond just one neighborhood. If an HOA can ban firearms in common areas, where does that authority end? Could other HOAs across the country attempt the exact same thing? Or will state officials and courts step in and say these policies have gone too far? That is a debate that very well may soon be tested. So what do you think? Should an HOA have the power to ban firearms in common areas that residents use every single day? Or does this cross the line into restricting a constitutional right? Drop your thoughts below in the comment section. If you want the latest Second Amendment news, court cases, and legal updates, make sure you subscribe and turn on notifications because this story is one we're definitely going to keep an eye on. And as always, I'll see you in the next one.